welcome to episode 7 of The Legal Scoop. I am Brendan Shannon, the host of this show, and I'm joined today by my esteemed colleague James Cousins. And we're going to talk about a recent win here at LOMAD. If this is your first time watching The Legal Scoop, this is our webinar series where we discuss notable wins that we feel that our clients would, and anyone watching this, would find interesting or useful in any way. So, James, why don't you go ahead and introduce yourself?
Hi, my name is James Cousins. I'm a partner at the law offices of Melissa Day. And when I'm not supervising the attorneys in the practice, I am litigating my own files, just like I have for the last about a decade and a couple of years at this point. So I have an interesting win today that I wanted to talk about because it involved the threat of litigation. We didn't have to litigate the file, and we were able to get the result the client wanted, which was to get the file closed and get the claimant out of the workforce for the employer.
Yeah.
Yeah.
So why don't you give us the basic facts? So you're talking about a settlement before having to go to trial,
Yeah,
basically?
Fully controverted claim for a knee injury involving a 30-something local truck driver. And he alleges that he has an unwitnessed accident, injures his knee very badly while unloading a truck. What was really interesting about the case and what gave red flags immediately to the employer, who has a large retention, was that people saw the claimant after the injury and nobody really noticed anything was wrong. And then what really was a red flag for them at the early stages was there was a coworker came to the supervisor and said, hey, this guy showed up to a basketball game after work that we all kind of play at somebody's house, and it looked like he hurt his knee there. So the file gets referred to us with that, and we get a medical report that just talks about, him hurting his knee at work. So we did a bunch of investigation and ended up getting the emergency room records, which were extremely interesting and led us down some very interesting paths in this case.
Okay, so I want to get into that, but my first question, which is kind of unrelated to the overall issue here, was the Good Samaritan going to be your witness?
Yes.
Okay.
He was willing to testify, but it created what I would call a Sherlockian mystery when we talked to him.
Okay.
I'll get you there. This is a really good one.
All right.
So we get these emergency room records that show that this guy shows up at the emergency room at like 10 o'clock at night, and the triage nurse takes a history from the guy saying that he was playing basketball and he jumped and he hurt his knee. Okay. And I'm like, wow, that's what our witness said. That's amazing. But I have this other medical record from a couple days later from a specialist, an orthopedist, that makes no mention of the basketball game.
Right.
So as I go reading through this ER record, because he arrived so late at night and in a sort of very busy emergency room, he ended up being triaged. And then there was an initial intake from the nurse at about 1 a.m. the next morning. His history went from triage nurse that he tells that he heard it playing basketball with no mention of work. At 1 in the morning, he tells the nurse that sees him when he's in a bed that he hurt his knee, he tweaked his knee at work, but then he hurt it again playing basketball. And so they take that history and they refer him to the on-site in-hospital ortho clinic, which he then sees the next morning at around 8 a.m., like first visit.
Wow.
And because it's right on site, so they waited for the on-call orthopod to show up, and he shows up, and he reports a history that makes no mention of basketball. So I have this one record from the ED that's like 12 pages long that gives 3 different histories, and you see it evolving from like 11 o'clock at night to 1 in the morning to 8 the next morning, and he goes from this is not related to work to this is totally related to work.
That's amazing.
So we get these records, and we interview the employer witnesses, and the supervisor says nobody knew anything about this, nobody knew what was going on, we had no indication he was injured, he was hanging around, like that accident didn't happen at the end of the day as far as the claimant was concerned. That happened middle of the afternoon.
Yeah.
So if he had hurt himself badly as he was saying he was hurt, he was using crutches and couldn't walk, you would have thought that something would have manifested right away or before the end of the day. Nobody saw him having a problem walking. He told nobody about it. He reported the accident the next day. So then I'm interviewing the coworker witness, and the coworker witness says he showed up to basketball really limping and hobbling. And he got himself out onto the court and tried to play, and everyone said, a bunch of people were there, including our witness, and said, "Man, what is wrong with you? You're hurt. You got to go to the hospital."
Okay.
But he showed up over an hour and a half late for this basketball game. Like, apparently they all just show up at a friend's house. So something happened between the time he was at work and the time he shows up at this basketball game that's entirely unaccounted for.
So at this point, I'm assuming because of the kind of difficulty of saying that it happened at the basketball game with that fact is why you were interested and the client was interested in maybe settling it before going to trial?
Yeah, I mean, the report to the client, it read like something out of a murder mystery. It's like, why would this witness say this if it wasn't true? Because the witness seemed to be on our side, but it's not consistent with the theory that the claimant hurt himself at the basketball game. But it's also not consistent with the claimant hurting himself at work like 3 hours, 4 hours earlier. And there's this period of time that's unaccounted for.
Yeah.
Now, what we were able to do, we never got to ask that question of the claimant. That's the real shortcoming of this, is we really wanted to know what happened in between. I became convinced that something had occurred. There had been some kind of accident, not at work and not at the basketball game, that had occurred, and he was going to sort of fabricate this work accident.
Yeah.
So we go to a pre-hearing conference. All these records are in the file. I name all my witnesses. The claimant is obviously nervous because it's unclear why we've named a coworker that saw him playing basketball. The medicals that the judge is directed to look at by claimant's attorney makes no mention of the basketball game. We raise all of our defenses and point out that we believe that this is not a scope and course case. This claimant was injured off hours at some other time, either at the basketball game or between work and the basketball game.
Yeah.
And claimant's attorney calls me after the hearing and says, well, what is this defense about? And I just said, look at the ER records. And look at the 3 histories of the ER records, and you tell me that that's not going to make your client look foolish. All the while, we've sat and talked with the client, and the client's response is, this looks like it may be a difficult case to defend because he said, she said. The records seem to support, including our witness testimony, that the claimant was injured before the basketball game occurred. Our only defense at that point was basically not it. Right.
Yeah,
and we didn't.
Credibility.
Yeah, we didn't know any other. We had no solid proofs. So our instructions were: get this case gone, do what you can, but he cannot be on the books. So after sufficient threats, chiding, cajoling of claimant's attorney, we got a settlement demand for a very small amount, and sort of following Melissa Day's theory that if what they asked for is usually twice what they would actually take, we were able to negotiate it down to a very, very small, essentially nuisance withdrawal of the claim. We agreed to pay the medical on a diagnostic basis, which was essentially an ED visit.
Yeah.
That might have been to that point the highest value item in the case, apart from any potential surgery. The claimant also agreed at that point, having seen the witnesses that were going to be testifying against him, that he was not really interested in going back to work there, and so he agreed to a voluntary resignation as well.
Wow.
So, essentially we scared them out of proceeding with litigation on the file based on what we were displaying. We were showing them that we had a lot of tools to use to defeat the credibility issues in the claim.
Well, I think one of the more basic lessons there is always go through the ED records.
Yeah.
Very closely.
Read them line by line.
Yeah.
Don't just take for granted that huge swaths of it are just
Blood
repeats.
tests.
It hadn't crossed my mind until I was reading through it, and I came upon the second history. I'm like, oh gosh, that's the second provider who saw him. And every time I've been in an emergency room, I remember every doctor who sees you, the first words, or provider, the first words out of their mouth are, what happened?
What happened? Yeah.
What happened? What's going on? And this guy's story was just, you watched it morph through a single medical record. It was really something. I still I'm going to be bothered for a long time about what really happened here.
Yeah.
Because we'll never know. All we knew is we had an unwitnessed accident with a presumption. We had a lot of evidence that suggested the accident didn't happen at work. Whether it was substantial or not was really going to rely on how this claimant testified, how our witnesses testified, and essentially the predilection of our judge.
Right.
And when you're dealing with one of the random downstate judges that are randomly assigned to files, knowing that the person that you're in front of for a pretrial is not going to be the person who's probably hearing your testimony, you're really throwing the dice that you're going to get a claimant or carrier-friendly judge come time for trial.
And you're up against the uphill battle of fighting against the presumption.
Right.
You know, the Section 21 presumption here.
And you really have two classes of judge, right? You have a class of judge that if there's a gray area, they're always going to default to claimant.
Yeah.
And then you have the class of judge that says there's a gray area, they actually start to dig into the case. This would have required a judge to dig. And so a judge who was not willing to spend any time on this file would have been an auto lose, I think.
Yeah.
Because they would have resolved any of the conflicting facts or discrepancies in the claimant's favor. There was a rational chain of presumptions that the judge could make, which is, it's like, well, the basketball game wasn't the cause of the injury because he showed up injured, so it had to have happened before. And if I'm going to assume it happened before, the only thing that I know in this record that happened before is the claimant's going to tell me he hurt his knee at work.
Yeah.
He's not going to admit to the intervening accident that we believed happened. And that any rational fact finder, absent presumptions, would say, I just can't believe this story. It makes no sense, right? But in comp court, the judges are sort of, they're habituated to having to swallow things that are somewhat incredible because we can't prove exactly what happened because that tends to be the level of our burden. So the client got what they wanted. They basically paid less than the litigation fees to carry out the case to an RD and possibly maybe an appeal, depending on how careful we were with time on it. But they paid that and got the claim gone, no future medicals, and the claimant's no longer working there.
Right. And it's a knee claim, and knee claims are one of the more expensive body sites you're going to find.
Yeah, our 30-something is going to reopen that claim when he's 50-something, and there's going to be a TKR in that case. You know, and there's no longer a special funds to be, you know, like make that somebody else's problem.
Right.
So, you know, open claim on the books for a knee with a young kid. He's probably never going to go back to work there anyway, and I think we all knew that.
Yeah. So this is a great example of how you can win a case without getting into fancy case law or anything like that. It's more.
I know it was like I was kind of wasted on this because I love case law. You know that, right?
Yeah,
it was like,
exactly.
I want to win a case where I can prove that there's law on point.
Yeah.
And that we're correct, and that even assuming the facts favorable to the claimant, we still win. That's my favorite pattern.
Yeah.
But this was a case where it was just all about the credibility of witnesses and whether the story that he was going to tell could be swallowed and whether our witnesses came off as credible.
And having the case prepped well from the beginning so that you could basically win the case before even having to go to trial and develop the record through testimony and all that.
Yeah, you could even say that this case was won by the staff here. Right? Because I got that file, and we knew we needed those ED records, and they weren't in the file.
Right.
All we had was the follow-up notes that the claimant had been given, those handouts. We knew that there was a lot in that file, and we knew that the first ortho visit had occurred in conjunction with his ED evaluation. So we needed those records. So as soon as the file came in, the first thing we did was get a speedy get a HIPAA and really hammer the hospital. And hospitals are not happy to respond to those record requests. And we sent a subpoena on short notice and said we need these records right away with a cover letter specifically saying we don't need all the rigmarole. We just need that. We need that complete ED note for this date of service. We know it's there. And we were able to get it in time, obviously, to get it into the pre-hearing conference statement, get it into the file. Then the claimant had some explanations that he was going to have to give that up to that point, even our own witness was going to say he showed up to the basketball game injured.
Yeah.
Right? And so what do we have? We have what could look like a red herring. He showed up late. Well, why were you late? Well, all he's got to do is give us some story about I stopped and got some food and I got some gas.
Some ice.
I got some I got some ice for my bum knee, right? That was what we were hoping. But he's going to tell us some kind of story that we have no way of contradicting because nobody at the employer was even aware the guy was injured until the next day when he reports, I hurt myself at work, then I hurt myself at basketball, and now I have a comp claim and I can't work anymore.
Yeah.
Well,
I think that's a pretty impressive win, and it showcases, as always, what we do here at LOMAD, which is prepare.
Yeah, be prepared, man. Quality over quantity, and be prepared. It is worth all the time that you're willing to spend on a good attorney to examine your file.
Yeah, well, and it was like you said, a full team effort.
Yes.
Right down to the staff.
The client themselves, the employer on a high deductible at the local level, who's not involved in risk, right, except for the reporting, says there's red flags on this case because we know about this basketball game. Then we've got the higher level at risk for the self-insured or for the retention employer saying, we think we have a case, we're starting to do an investigation, we need you to help supplement it and start put together the defense of the file. And then the staff at LOMAD went crazy and got stuff real fast. We were able to communicate well with the TPA and the insured and make sure that everyone was happy with where the case was going, even to know as we're litigating the file, right, that we have a big problem now that our star witness has told us that what we thought was true, because the claimant's own history says he hurt himself playing basketball. That's the mystery. Why would he lie to the emergency room nurse at triage and say, I hurt myself playing basketball, when he showed up to basketball already injured? That was the big trick. Why would something had to have happened? Something that was so embarrassing that he was willing to fabricate a story, and you could see him coming up with it on the fly.
I feel like we need the Unsolved Mysteries music to
I know,
to close
that's
this
really what it
episode
is. Yeah.
Well, James, congrats on your win. And stay tuned for next month's episode 8 of The Legal Scoop, where we'll have another attorney to talk about an inevitable win.
It'll happen. We'll just have to pick which one's best.
Yeah. Thank you, James.
Thanks.